Thank you for taking the time to listen to the short presentation. By way of introduction, my name is Muireann Reedy and I'm a Senior Associate in Dillon Eustace's Regulatory Investigations Unit. The next couple of minutes, I'm going to look at whistleblowing under the Protective Disclosures Act 2014. And whistleblowing is something which has probably become more prevalent in recent years, probably due to the fact that people have become more aware of the protections which are available to them. So the Protective Disclosures Act came into force on the 15th of July 2014, and the aim of the Act is to protect workers from reprisal where they expose wrongdoing which they encounter in their work. The definition of workers is very broad and includes not only employees, but also people who are working as agency workers or contractors. So in order for the disclosure to be protected, three main criteria must be met. Firstly, that the worker has a reasonable belief that the disclosure tends to show one or more relevant wrongdoings. Secondly, that the information came to the worker's attention in connection with his or her employment. And thirdly, that the disclosure is made in one of the manners set out in the Act. The motivation for making the disclosure is irrelevant, and the only exception to that is if it relates to revealing a trade secret. And in that specific scenario, the whistleblower will need to show that the disclosure is made to protect the general public interest. Also, in an unfair dismissals case concerning a protected disclosure, the level of compensation which may be awarded can be reduced by up to 25% if it can be shown that the reason for making the disclosure was not connected wholly or mainly to having the wrongdoing investigated. The Act requires all public bodies to have whistleblowing policies and procedures in place. It doesn't say anything about organisations operating in the private sector, but obviously, as a matter of good corporate governance, all firms should have whistleblowing policies and procedures in place. Now, I mentioned just a moment ago that in order for a disclosure to be protected, it must relate to irrelevant wrongdoing as set out in the Act. And as you can see from this slide, the list of relevant wrongdoings is pretty broad. It includes everything from concerns about a criminal offence being committed to the health and safety of an individual being endangered, and also the unlawful or improper use of public funds. It also covers a situation where a worker has a concern that a person has failed to comply with any legal obligation, aside from one concerning their own contract of employment. And the way the definition of relevant wrongdoings is phrased in the Act not only covers wrongdoings which a worker believes has occurred in the past or which are ongoing, but also those where the worker believes are likely to occur. And that applies to all categories of wrongdoings with the exception of the one concerning an act or omission of a public body. Interestingly, the Act also states that a disclosure about irrelevant wrongdoing, whether it occurs in Ireland or abroad, will be covered, as well as acts which are prohibited by foreign law. And the idea behind that is probably to protect workers who are working in a multinational. So a disclosure must be made in one of the manners set out in the Act in order to qualify for protection. And the Act has a step disclosure regime. And what I mean by that is, depending on the party to whom the disclosure is made, different conditions apply for the disclosure to be protected. Now, the Act is designed to encourage people to make disclosure to their employer, as less number of conditions need to be met in that scenario for the disclosure to be protected. So bearing that in mind, I've grouped the disclosure recipients under the Act into three main categories. In category 1, you have those parties to whom the least number of conditions need to be met for the disclosure to be protected. And in category 3 relates to where the most number of preconditions need to be fulfilled for the disclosure to be protected. In category 1 then, you have the worker's employer, a minister where the worker is employed by a public body, a legal advisor and a trade union official. You also have disclosure to another responsible person, and that covers the situation where a worker makes a disclosure to a person where he or she believes that the relevant wrongdoing relates to their conduct or for something which they have legal responsibility for. Where disclosure is made to somebody in category 1 then, the worker just needs to show that they reasonably believes that the information tends to show one or more relevant wrongdoings and that the information came to their attention in connection with their employment. Disclosures can also then be made to a prescribed person if it falls within certain subject areas, And currently 73 people are set out in the list of prescribed persons. And these include staff of the Central Bank of Ireland, where the disclosure relates to a breach of financial services legislation, and also to the Director of Corporate Enforcement, where it relates to compliance with the Companies Act. Where a disclosure, though, is made to a prescribed person, in addition to the two requirements I've just met, the whistleblower will need to show that they had a reasonable belief that the allegation they're making is substantially true, and also that the disclosure falls within the prescribed person's remit. Finally, then, you have disclosure in other cases, and that refers to disclosures which are made to an external third party, such as, for example, the media. In that case, there are numerous conditions to be met for the disclosure to be protected, one of which is that the disclosure must not be made for personal gain. So what are the protections then under the Act? Well, firstly, the identity of the whistleblower is to be protected, but there are some exceptions to that. Some examples of the exceptions include where the disclosure recipient reasonably believes that it's necessary to disclose the whistleblower's identity in order to effectively investigate the wrongdoing or to prevent serious damage to the state's security or to public health. From an employee's perspective, importantly, the Unfair Dismissals Act has been amended to provide that where an employee is dismissed for having made a protected disclosure, it'll automatically be unfair. And in that scenario as well, the maximum compensation which can be awarded has been amended to up to 5 years remuneration, whereas normally compensation in an unfair dismissals case is capped at up to 2 years remuneration. Also, the Act provides protection for workers who are penalised for having made a protected disclosure, and also provides that they may be compensated with up to 5 years remuneration in that scenario. And the definition of penalisation is pretty broad and includes suspension, demotion, and transfer of duties. The Act also provides immunity from civil liability, except in defamation cases where the defence of qualified privilege will apply. And similarly, in criminal proceedings, for an offence concerning the disclosure of information, it will be a defence for somebody to show that they reasonably believed that the information disclosed was a protected disclosure. Lastly then, the Act provides a right of action to any person who suffers detriment at the hands of another, either because that person or another person has made a protected disclosure. I suppose this provision would protect family members of a whistleblower where they may suffer adverse consequences as a result of their action. Again, the definition of the term detriment is pretty broad and includes intimidation, discrimination, adverse treatment, and harassment. Just before I finish up, I think it's worth mentioning the EU Whistleblower Directive. And this must be implemented into Irish law by the 17th of December next year. And that directive protects workers who report certain breaches of union law which they encounter in their work, including breaches relating to financial services, prevention of money laundering, public procurement, and data protection. And I suppose a key change which that directive will bring into force is that all legal entities operating in the private sector with 50 or more workers will be required to establish internal whistleblowing channels. And not only that, but the directive also specifies particular procedures which must be followed when a report is received into an internal whistleblowing channel. And these include things like setting out the time frame for receipt of the report to be acknowledged, and also providing feedback to the whistleblower. The protections of that directive are broadly similar to those provided under the Protective Disclosures Act. That brings me to the end of this short presentation. So I'd like to thank you again for taking the time to listen. And if you have any queries on whistleblowing or on the Protective Disclosures Act, please don't hesitate to give me a call or to get in touch with another member of our Regulatory Investigations Unit. Thank you very much.